Okay, there we're good. Um, okay, so hi, my name is Jared. This is Madeline, obviously. So our case was Michael Farley versus the state of Florida, and his case is he pled nolo contendere to 3 counts of sexual performance by a child in violation of Florida statutes, and basically his case was precipitated by an unrelated investigation in Texas in 2000, where a husband and wife were arrested in Dallas for child pornography offenses. And from this, they had a list of names, email addresses, stuff like that, and Farley's name happened to be on it. And so this was the only connection to Farley. He had no previous things, so this is how the case started out. Do you want to start with defense, or do you want to start with prosecution?
Sure. So I'm serving as Farley's defense team. So as we describe this case a little bit further, you need to know that in Florida, subjective entrapment is statutorily defined. So there's, very specific things that you have to meet for it to be entrapment. So the first thing that so basically, the government sent Farley an email to the email address that had been found in Texas. It was designed as a spam email. So, inducement. The government came to Farley. This wasn't an ad in a newspaper or, someone out on the street. The government specifically targeted Farley and sent the email to him. Following this, there was a series of email exchanges, eventually going to a website and eventually getting him to order pornography, specifically child pornography. However, the government agent specifically said repeatedly throughout the process of emails that this was a private transaction and that the government would not be involved at all, and that basically the government served fraudulent representation of the government's involvement, which is part of inducement. So part of inducement is fraudulent representation, and very clearly a government official saying that they will not report what is occurring to the government is fraudulent representation. The second thing has to do with predisposition. So Farley had no previous, and in Florida, predisposition is, the key word is pre. So it is that there is some evidence that in the past Farley would have done this. So he had no prior sexual charges of any kind, let alone any interactions negatively with law enforcement. So this was his first offense, you might say. So this wasn't a previous or repeat behavior of his. So the government's request for this conviction has made it that this seemingly law-abiding citizen who probably wouldn't have done this without government interference has now committed a crime. So this is subjective entrapment.
Okay. The reason entrapment is, I think, not previous, or actually not relevant in this case, is the fact that there's certain levels to entrapment, and that's obvious, whether an official eggs somebody on into doing it or they just post an ad. But this, for entrapment, 3 questions have to be answered. One is whether a government agent induced the defendant to commit the crime charged. The government agent didn't induce it necessarily. He sent an email. He only sent one from what the case says, and Farley responded to it. And with his response, he sent another. Farley responded to it. He only sent one after each one of Farley's responses, and it eventually led to the purchase of child pornography. Two, whether the defendant was predisposed to commit the crime charged. He wasn't predisposed at all. He was just sent a clear email. It wasn't saying do this or because this is going to happen or something like that. It wasn't a threat, nothing. It was just he did it because he saw an email. And three, whether the entrapment defense should be evaluated by the jury. And it was evaluated by the jury. So yeah, entrapment, I mean, yes, there's obviously levels to it, but unless it is clearly violating certain levels of what was I can't remember the word right now. Yeah, but it's still, he's not inducing it to him at all. It's just an email and a response back and forth. So we have to think Farley still had a choice to pursue these sexual desires, and he did. All we did was send an email because we had a list of names, and he happened to be on a list of names from a previous sexual offender's case that had to deal with the same thing, child pornography. So it's just simple that Leach, the county sheriff's office, and Broward, their task force Leach, followed up on a case, such as a list of names that a child pornography or the husband and wife from this previous child pornography case had. It's just simple following up, and it eventually did lead to Farley's arrest. So I think, yes, he had no predisposition. He had never committed a crime before, but why would he be on a list of names from these persons' address? Email address, addresses, and credit card information was uncovered from Farley, just from a previous investigation.
Okay, so first I want to quickly define inducement. So inducement, especially in Florida, is defined as any government conduct creating a substantial risk that an otherwise law-abiding citizen would commit an offense, including persuasion, fraudulent representations, threats, coercive tactics, harassment, promises of rewards, or pleas based on needs, sympathy, or friendship. So, once again, I've already discussed how on the website that they linked Farley to, there were 10 instances in which protection from government interference was expressly promised to Farley, which is a fraudulent representation. In addition, so the government agent in charge of emailing Farley provided some basic details on what he was interested in, and then Hall, the agent, kept asking Farley for more and more and more specificity and more explicit details on what Farley wanted. So he kept upping the ante. And then, so for predisposition, predisposition in general, especially in Beatty, which is a case that is often referenced during this case, is found to be absent when the defendant was not known for deviant behavior prior to the brush with law. And predisposition is also not present when one has no prior criminal history related to the offense at hand. So no evidence was ever found that Farley had ever purchased this type of pornography before this account, and no pornographic materials were found in his home, and he'd never been arrested for anything in his life. However, the list of credit card numbers and email addresses that Farley's name and email address was on, found in that Texas home, was not specifically linked to that couple's exchange in child pornography. It was just happened to be in the evidence collected at that home. It could have been for anything.
Okay. Yeah, it could not have been linked at all, and it was, I believe, proven that it wasn't linked, but it's still just by Leach following up on a case and following up on a certain lead they have. And as for predisposition goes, I mean, Farley had never committed other offenses. He never committed a crime before. I'd never seen anything with this behaviorally. But it's still, Farley has to know that child pornography is still illegal, and whether or not he's being induced into it. I mean, if somebody, regardless of you think the government isn't involved, is say a random stranger comes up on you and keeps asking you what your sexual desires are and keep asking more and more, I mean, you're just going to tell them, oh, I would like child pornography. I mean, it's still illegal, is my main argument to that.
Understandable, yes. But we have to remember that the court is not required to, but is induced to dismiss cases and free people of charges when the government desire to convict for something leads to a regular law-abiding citizen who would not have committed the crime by the government. Farley wasn't predisposed to this. He wouldn't have asked for these things if he hadn't been repeatedly prodded about it by these government agents.
Then again, even if he is prodded for this, like, again, Farley has to know this is illegal to some extent. And yes, inducement is a very serious charge at the KC, but the state maintains, all similarities aside, that the law enforcement conduct in Farley's case simply did not rise to a level of offending due process. To offend due process in the form of entrapment with no predisposition, it has to be outrageous and prejudicial. So in this case, for Farley, it wasn't at all. It was a simple email back and forth that led to the arrest of Farley for buying and possessing child pornography.
So I want to bring up another case in Florida from 1994, which was State versus Fino, which was a loan sharking sting. And the court wrote the following. They said, when the government supplies all instrumentalities of a crime, controls all of its aspects, and teaches the intended target how to commit the crime for the purpose of arresting him, the court should find here that there was no crime at all without government involvement. So, and the other thing I want to just reiterate is that the reason this violates due process is it wasn't that the crime was manufactured. It's that it was manufactured under a promise of protection from government knowledge and interference.
But even if something offers you protection from government interference, if the act you're doing is illegal, you shouldn't have protection from that. Regardless of what a website tells you that you may trust or not, it's still clearly illegal. And if somebody tells you, oh, if you murder this person, but the government's not going to be involved, I mean, you clearly have to think it's going to be.
Understandable. However, it still fits the definition for fraudulent representation, meaning that this does qualify as subjective entrapment, and Farley should be cleared of his charges.
That's about all I have.
Good.
Okay. Yeah, I think so. How do I...